The following program is made possible in part by the Dayton Bar Association.
Hey, good evening and welcome to You and the Law. I'm Mike Monta, producer and host for tonight's program. And because it is the Christmas and holiday season, we are going to be talking about offenses like drunk driving and OVI and license suspensions and related topics. Joining me as guests on tonight's show, an esteemed panel. Judge from Kettering Municipal Court, the Honorable Fred Dressel. Did I get that?
You did.
All right, Fred. Good. And doesn't always happen, but Assistant City Prosecutor for the City of Dayton, Mr. Matt Courtjohn, and a fine defense attorney in the field of OVIs, DUIs, Mr. Brock Shaneline. Now, before we get to questions for our panel, let me remind you that You and the Law is a monthly presentation produced here at the studios of the Dayton Access Television. DATV is on Time Warner, and it's the public access channel for the Time Warner cable network in Dayton. The program is also cablecast north and south via the auspices of the Miami Valley Cable Council, and you can see it live. Hopefully you can see it live on Channel 6 and 993 if you have the cable. You can also watch us live streaming at datv.org, so if you're not watching on television, we hope you're watching streaming. The executive producer for the program is former domestic relations judge and the originator of this show, Judge Mike Brigner. We are live right now, and it's a call-in audience participation program, and from time to time we'll see the number to call in, which is 223-5311, and do our directors have that? Let's see. There. No, that's not it. Is that it? Is that it, Tiki? 903? Share that again. That's a surprise to me. They made a mistake. You mean I'm right? 223-5311. They'll show it again. There we go, 223-5311. I've said it enough. If you're watching, you can call in. These fine experts on DUIs will answer your questions. No question is, some people say they don't want to call in. Our questions are dumb. There's no dumb questions. And there's no dumb answers on this show either. Well, it could be proven wrong, but probably not. Let me first ask our guests on today's program to introduce themselves to you and tell you a little bit about their backgrounds and familiarity with tonight's topic. And then we'll get on with some questioning. And we'll turn first to Judge Fred Dressel. Good evening, Judge.
Thank you, Mike. I'm Fred Dressel. I am a judge on the Kettering Municipal Court. I've been a judge for about 19 months now. Was just reelected about a month ago. But I've been in the legal community in Dayton for over 30 years. I graduated from Ohio State University Law School in 1981 and came to Dayton in early 1982. I worked for 6 years as a Montgomery County Assistant Public Defender, during which time I handled many criminal cases, traffic cases, both felony and misdemeanor, and many OVI offenses. After a 5-year corporate stint, I returned to the world of private practice for 20 years, and in my private practice I did a fair amount of criminal traffic and OVI work. During my time in private practice, I sat as an acting judge for many years on the Kettering Municipal Court before actually becoming judge in the spring of 2014.
Thank you, Judge. Good to have you with us. Next, we'll turn to Assistant City Prosecutor for the City of Dayton, Mr. Matt Courtjohn. And Matt, good to see you here tonight.
Well, thank you for having me. I've been with the City of Dayton Prosecutor's Office I'm going into my 8th year now. I've been an attorney for that length of time as well. I graduated from the University of Akron School of Law, went to Indiana University before that for undergrad. In the City of Dayton Prosecutor's Office, we handle only cases that occur within the territorial limits of the City of Dayton, and we handle only misdemeanor cases. Since most OVIs are going to be misdemeanors, that is a pretty large part of my practice and a large part of the cases that I see and that I prosecute. So I've been doing OVIs for the 7 or 8 years that I've been with the office. I've also been gone through certification or training to become certified in doing field sobriety testing, similar to what officers do when they make arrests. So between that, the ongoing training, and the cases that I see on a daily basis, we deal with a lot of OVIs.
Thank you, Matt. And good to have you here also. And we always turn to the defense attorneys last because we always think that maybe they have the most knowledge and the most flexibility in applying the law. It's just my opinion. Might not be right. No. But Brock Shainline, been in Dayton for a better part of the last decade, and good to have you with us tonight.
Good. Thank you, Mike. I went to OU for my undergrad and UD for law school. I have been a practicing defense lawyer here in Dayton for, I think, getting on 7 years now, and I was a law clerk in a defense firm for 3 years before that, so I've been in it for about a decade. My partner, Larry Denny, and I, we focus on criminal defense and litigation, and by the luck of the draw, most of what we do is OVI. And we also carry police certifications or NHTSA certifications to give and administer field sobriety tests to individuals. And our goal in defense work is to protect citizens' rights and to make sure that they are familiar with the rights that they have vis-a-vis the government. That's what we do.
Great. Thanks, Brock, and good to have you here. And if I didn't say before, it was up on the screen, we are sponsored by the Dayton Bar Association. Bill Wheeler's the director. We'll talk a little bit more about them. This is a commercial-free program, so whatever you hear from me is pretty much the commercial. But anyway, a shout out to them, and we'll talk a little bit more. Let's talk a little bit about OVIs, and Judge, we'll turn to you first. What is OVI, DUI? And how does it apply in the law, and what do we do about it? It's drunk driving, right?
It's drunk driving.
That's what they call it.
It's what it is. As Matt alluded to in his introduction, a lot of what we do in municipal court is traffic law, and a lot of traffic law is OVI.
Kettering is one of the busiest courts in maybe the Tri-County, isn't it?
It's a very busy court. Our jurisdiction encompasses the cities of Kettering, Centerville, Washington Township, and Moraine. So we really have 4 different police agencies that we deal with: the City of Kettering Police, the Centerville Police, Moraine Police, actually 5, the county, Montgomery County Sheriff's Office, and the Ohio State Highway Patrol, because of 675 and 75 passing through our jurisdiction. Everybody knows, don't drink and drive. That's been a slogan on public service announcements for decades, ever since probably I was in college. But it continues.
Drinking is not prohibited while driving, though, is it?
No, it is not. And therein lies a lot of the legal issues that we deal with. Probably, if I've had one question asked me in my years as a lawyer and now as a judge, how much is too much? And it depends on so many factors. But the law has evolved to the point where the actual offenses of OVI are categorized in different ways. There's a general catch-all provision, which we all call the A1A provision of 451119, which is proving that somebody, one, operated a motor vehicle, two, that they were under the influence of drugs or alcohol that impaired their ability to operate a vehicle. In that case, there's an element of proof of the bad driving. There is also a whole set of the DUI law sections that make it a crime to drive a motor vehicle with a prohibited concentration of alcohol in your blood, breath, or urine. And depending upon the situation, you may be asked to submit to one or more than one of those tests. And in that instance, the offense is having the prohibited alcohol level and not necessarily your coordination, how well you drove or didn't drive. That opens the door to a lot of issues as far as the legality of stops, issues such as probable cause, issues for the person that is in that position as to whether they want to submit to a chemical test or refuse a test. But the OVI offenses themselves are a large percentage of what we do. And one of the things about OVI that makes it particularly challenging for the defense bar is, and the court's discretion is somewhat limited because there are mandatory penalties in OVI. Many crimes, there are not mandatory penalties. OVI, there are mandatory penalties for first, second, third offenses and beyond, and they are escalating. And they do limit the discretion of the court to sometimes give people a more lenient sentence. Our hands are tied by those minimum penalties set forth by statute.
Well, let's talk about the penalties in a little bit, if you don't mind, and some of the programs that the courts use, things like that. But I wanted to turn to Matt as a prosecutor. Obviously, you go to work every day downtown, and the cases come to you. Even though I believe you are certified, if you wanted to give a field sobriety test or a chemical breath test, you could. But what is it that you see each day as far as these alcohol-related offenses?
Sure. Typically when I have a case that ends up on my desk, and I'm usually looking at least one OVI case probably on a daily basis, if not more, I'm looking at a variety of things, basically from the very beginning of the person who has been charged with OVI, their interaction with the police, all the way up through any kind of testing they did, whether it would be field sobriety testing, whether it would be actual chemical testing, like taking a breath test or taking a blood test.
Let me stop you just for a second.
Sure.
Tell our viewing audience what a field sobriety test is.
Field sobriety tests are tests that law enforcement will use when they have reasonable suspicion that a person is under the influence of alcohol while driving a vehicle.
How do they get under that reasonable suspicion? What are they looking for out on the highway?
Typically when an officer makes a traffic stop, the stop could be for driving that is indicative of being under the influence, or it could be something as simple as a speeding offense, or maybe they ran through a stop sign, or they failed to signal a lane change. But when the officer makes his initial approach with the driver of the vehicle, he's going to be looking for the typical signs that a person that may not even be trained to look for alcohol intoxication would be aware of. Odor of alcohol on the breath, bloodshot glassy eyes, sometimes a flushed face, slurred speech. These are all things that the officers are going to be looking at. Typically on a stop, they're really only supposed to be taking as much time as it requires to accomplish the purpose of the stop. But if they say they pull you over for speeding, and after talking to you for a while, the officer has suspicion that you might be under the influence of alcohol, or maybe even under the influence of a drug of abuse, they're going to extend that stop long enough for them to be able to investigate whether you may actually be impaired.
So they're going to find out some things by their power of observation and training.
That's right. And that's where the field sobriety tests come in. These are tests that, there are a lot of different tests that officers can do, but there are 3 main tests that have been approved by the National Highway Safety Traffic Administration, NHTSA, we call it for short. And they are basically tests that are supposed to give an officer, without using a breath test or without doing maybe a blood draw, a way for the officer on the roadside to be able to determine whether the person is impaired. Typically, the tests are meant to test whether a person is able to complete a divided skills test. A divided skills activity. Driving is a divided skills activity. You have to watch the road, operate the gas. Right, you have to be coordinated. And that's what those tests are designed to monitor, whether or not you have the coordination that a sober driver would have, or if you have the lack of coordination that somebody that is under the influence might have.
Okay. And also perhaps the breath tests.
Sure, and that's what the field sobriety test is meant to say, okay, this is kind of a middle step, and depending on how you do on the field sobriety testing, if we do have reasonable suspicion that the person is under the influence, then do we need to take the next step to investigate the OVI, place them under arrest for OVI, and then that's where the actual chemical test, the breathalyzer or a blood draw or a urine sample will come into play.
Okay. You've been awfully quiet over here, Brock, for the past 10 or so minutes.
So far.
So you're in your office Monday, Tuesday, whatever, and perhaps someone calls for you, Larry. He's probably out working on his horses tonight, right? Something
Not
like
sure.
that.
It's a possibility.
And somebody says we have a potential OVI case or alcohol-related case. What sort of things are you looking for when you meet this person, or you meet relatives or whoever may want to hire you?
Well, when we meet with clients on the front end, we want to know what their goals are. We want to know, do you have an alcohol problem? Is this a repeat thing for you, or is it a first-time thing? What kind of remedies as far as treatment or license suspensions have you been charged with, and what kinds of those things are potentially upcoming in the future? But our main role on the defense side is to examine what the police have done, to examine what the reason was why they were taken out of the car, to examine the field sobriety test that they agreed to take when they agreed to take them, and to examine the records that are kept with respect to the breath test if and when they take a breath test. And the reason why we do that is to make sure that it was done correctly. There was a time, for example, in Ohio where the law required what we attorneys call strict compliance, or in other words, perfection, with field sobriety testing. That time is gone, but it still requires them to be pretty good, or what we call substantial compliance. And like I said, having the same certifications that police do, at least on the same manual.
Now, you've taken some of these certification exams also, so
Mm-hmm.
you're well versed in that yourself as far as talking with your clients.
That's right.
Okay.
And what that does, especially if we have a video, if we have a cruiser video of the incident, is that it gives the defense an opportunity to look at what's there, to see how well or how poorly they did on the test, and perhaps more importantly, to see how well the police administered the test. Because if there are flaws, if there are enough flaws in the way the police administer the test, they might not be able to be used against our client in court. And the same thing with a breath test. The government always has to show, if we ask them to show, that the breath test that they gave was taken in compliance with the Department of Health regulations. And if it was not, it might not be able to be introduced at trial. So that's our job.
Okay. Let me interrupt here. Our floor director tells us we have a telephone call coming in for us, so we'll take that call. Good evening. You're on You and the Law.
Hi, this is Madison from Washington, D.C.
Good evening.
Hi, I have a question. So say I am driving and I get pulled over for speeding or reckless driving. They give me a road test. They have me walk in a straight line, whatever it is they do, and I fail it miserably. Obviously, I am under the influence of something, so they give me a breathalyzer test and I pass it. So would they then have the ability to bring me in to test me for other drugs, or would they have to let me go?
All right, that's interesting. And that was Madeline from Washington?
Yes.
Good. Did we all hear the question?
I think so.
I think so.
All right. Why don't we repeat it, whoever heard it best here, and then we'll... I believe the question was, you're going along, you're speeding, you're stopped, speeding or something else, and you're tested, and wondering if you can be tested for other things also, and the validity of the test.
Yep. My understanding of the question, with the addition of the speeding thing, it sounded like she asked, if I'm stopped and I do the test, she said, where you walk in a line. It's called the walk and turn.
Okay.
And then I fail it miserably. But then I pass a breath test, can they also ask me to take another form of a chemical test? Was that it?
I think that sounds about right.
Okay. Yes.
I think the answer, and you might get a different analysis on this from all three of our panelists tonight. I think the answer is yes.
Let's see.
And I should note that just because someone performs poorly on that test might not mean that they are intoxicated. And so if, for example, if you blow under, that also doesn't necessarily mean that you are not impaired by alcohol. And so police at that point, depending on, in short, the rest of their investigation, they may have grounds to request another chemical test from you, that being blood or urine.
And some of that may have to do with the fact the impairment might not be from alcohol, it might be some other substance.
That's correct. It could be, and the OVI laws punish driving under the influence of alcohol, a drug of abuse, or a combination of both. Those are kind of the three categories. And so, yeah, absolutely, a law enforcement officer, usually, if he's properly trained and there's something causing the person to do poorly on the field sobriety test other than alcohol, they may kind of skip over the breath test and go straight to a blood draw, which would be used to detect drugs of abuse, or they may ask for a urine sample. But law enforcement officers basically have a 3-hour time period in which they can obtain a sample from a person, and they can ask for, essentially as many samples as they think they need in order to figure out what it is that's causing the impairment that they're seeing.
Judge, these tests aren't necessarily mandatory, and the people might have some rights to not take them, or?
That's correct, Mike. And just touching on one more thing there, oftentimes we do see situations where somebody may be under the influence of a combination of drugs or alcohol, and sometimes the person, having felt inconvenienced by taking a test, maybe having passed it or thought they passed it, thinks it's over and I've done what I've got to do, and if you're going to make me do more, now I'm mad and I'm not going to do it. But I think Brock spoke correctly. The law does give them the right to test. If they feel something, you may be impaired and well, you tested under for alcohol, but there may be some other substances causing impairment. But, and the question as posed just now as to whether you have a right to refuse a test, the law in Ohio, you can refuse a test, but there are consequences for doing so. And the most dire of those in the short term is you will lose your license immediately on the spot after being advised of your right to refuse, but you will be advised that if it's called the Form 2255, they will review that with you, give you the option to take a test, and if you refuse, you will be placed under a suspension, and that is a 1-year suspension on a first offense, 2 years on a second refusal, 3 years on a third. And those refusal violation suspensions will remain in effect even if you are acquitted ultimately of the OVI, assuming that there's not some flaw in the issuance of the suspension.
Okay. Anything else to add, gentlemen?
I think we got it.
All right. Do you have any follow-up on that,
No,
Madeline?
thank you so much.
I'm sorry, we didn't hear you.
Oh, I'm sorry. No, thank you so much.
Okay, thank you for calling. We're going to take a very short break here to let you know that you're watching You and the Law on DATV. We are a live call-in show, and as you just heard, we had a call from a young lady from Washington, D.C., We do stream live, and apparently that's, I don't think our TV goes that far here in Dayton, does it, all the way to Washington. We are coming to you at Channel 5, or in the suburbs, Channel 6, and I think 993. I'm going to have to have somebody tell me whether that's true. And streaming live, datv.org. Let me tell you a little bit about the Dayton Bar Association, since they are so kind to sponsor us each and every year. The Bar Association's been around since 1883, which is over a century ago, and none of us were practicing then. Were you?
I don't think
No,
Larry might have been.
I was going to say, not even Larry.
Larry Denny, yeah. The Bar Association, with Bill Wheeler as its director, provides many services for the benefit of the citizens of the Miami Valley, some of which are a lawyer referral service. If you do not have a lawyer, you need assistance locating one, call the Bar Association at 222-6102, or if you forget that one, 222-7910. Is that right, you think?
Sounds right.
Yeah, okay. Nobody disagreeing. Let me see. I might have that somewhere. 7902. 7902. We have a notary public service. You can become a notary by taking a test. They don't just give you a stamp. You have to take a test. And then you can notarize things for your employers or in your neighborhood if somebody needs one. Wills for Heroes is one of our fine programs started not too long ago, where volunteer members of our Bar Association, when we say volunteer, that means they're doing it for nothing. Create wills for emergency first responders, firefighters, police, and EMT. So if you fall into that category, you don't have a will, call the Bar Association at that number I gave you, 222-7902, and they can tell you when the next event will be. I think it's more of an event than an episode. They tend to episodes, I think. Volunteer Lawyers Project assists the disadvantaged, and founded and supported by members of the Bar Association. So those are some of the things that we do, and we thank the members who do that. There's also a Speakers Bureau. If you want somebody from the Bar Association knowledgeable about a subject to talk about a group in your area, school, or whatever, call down there and they'll provide you with a speaker, usually pretty good ones. So we have a little less than a half an hour. We're talking here about OVI and related alcohol. I keep saying episodes. Why am I saying episodes? It's maybe because we're on TV. We have an episode every month. But our guests are the Honorable Fred Dressel from Kettering Municipal Court, Matt Courtjohn, Assistant Prosecutor with the City of Dayton, and our old friend Brock Shainline, who's helping out some of our drunk drivers, I guess.
Allegedly.
Allegedly.
Yes.
Right.
And expounding quite knowledgeably. You know, I promised our viewers before we'd talk a little bit about penalties for OVIs, and maybe now is a good time to do that. So, Judge, would you like to
I'll take a stab at
help
it.
us out at that?
As we talked about a little while ago when we were first starting out, one of the things about OVI law is there are mandatory penalties. A first offense OVI carries, well, let me back up. Any OVI always carries a maximum penalty of 6 months in jail on your first two offenses. It always carries a maximum penalty of $1,075 on a first offense, $1,625 on a second offense. Those are potential maximum penalties. And there are mandatory minimum penalties as well. The court must impose a minimum of 3 consecutive days in jail, and there is one exception to that. On a first offense, you can be allowed to serve that in a driver intervention program. It's a residential weekend program, the purpose of that being alcohol education and assessment. The court has to impose a minimum fine of $375, and there is a license suspension that can be as high as 3 years on a first offense, must be at least 6 months, can be as high as 5 years on a second offense, must be at least 1 year. If you're unfortunate enough to get to a third offense, OBI becomes, rather than a petty offense, which most misdemeanors are, it's considered a serious offense. It carries up to a year in jail. The first 30 days are absolutely mandatory. There's a fine that could be up to $2,750. The first $850 are mandatory, and you could lose your license for up to 10 years. There's a minimum of 2 years, which is mandatory. When you hear these financial ramifications, it makes a cab fare seem relatively cheap, doesn't it?
Yeah. Judge, you're the first person then that a person charged with a drunk driving offense impairment would see in court. What rights do they have there? Are they expected to plead guilty, do something right away, or do they have options?
Just the opposite, Mike. Because it is such a serious matter, we want to make sure that anybody who is faced with an OBI charge is fully advised of their rights, and probably the most important of all those rights is the right to counsel. Pleading to an offense of this nature as a matter of convenience makes absolutely no sense, and sometimes people will attempt to do that. But
to get it over with.
To get it over with, you know, you're going to send me to the 3-day program, and generally on most first offenses, we tend to look towards treatment and use of intervention programs in lieu of significant jail time. That shouldn't probably be taken as a right to a minimum sentence, and I say that because what I do in my court may not be what another judge does in another court or another court does in another county. So the first thing that I'm concerned about is making sure that a person has legal advice, and I have shushed many people who want to tell me about the facts of their case and say, I'd like you to talk to your lawyer first. If somebody is unable to afford counsel, we make the public defender available to them. If they indicate they intend to hire Mr. Shainline or somebody, we will give them a continuance to do that.
And sometimes they might even have a defense, right?
Sometimes they do.
And you don't know.
And I don't know, and I don't want to have anything jeopardized for them.
Well, the next step, I guess, is a case would be set for what they call a pretrial conference, and that would get personnel like Matt and Brock into play, where, for want of a better word, you all do some negotiation about the case. So you would get the case probably after that for the pretrial. What is your role? What are you doing, Matt?
Well, what I always tell people, the purpose of the pretrial is to get a resolution of the case in terms that is acceptable to the defendant and to the prosecution, or if there's a victim in a case, to the victim. But leading up to the pretrial, a couple things will have happened. I will have gotten the case that will include a police report if the officer has completed one, a copy of the ticket, a copy of the chemical tests. In the city of Dayton, pretty much all of our cruisers are equipped with cruiser video, so I will make an attempt to get a copy of the cruiser video that shows the stop. And I am preparing for that pretrial to look and see whether or not I do want to make a plea offer, depending on the facts of the case, or whether this is something where I'm going to tell Mr. Shainline that his client's going to either have to plead as charged or set the case for trial. We've had a couple of those cases together.
Yes, we have.
Meanwhile, Mr. Shainline's going to send me a request for discovery. He wants to get all the things that his client is constitutionally obligated
and there's
to be able to
rules
see.
that tell the prosecution what they need to deliver and also what the defense needs
Sure.
to deliver.
And our goal is, I think, for both of us coming into the pretrial to have the same information about the case and to be educated about it. So if there's an offer to be made, I can put the offer forward. Mr. Shanline can make an offer himself, and I can accept it or not accept it. But we would like to get the case resolved at the pretrial stage if possible.
Well, let me ask Judge Dressel again. You probably don't have trials of more than a couple of % of all these cases, do you?
That's probably an accurate figure, and I get there's a couple of reasons for that. Usually, prosecutors, once they get some experience, are pretty skilled at these cases, and there's a very
devious.
I'm not going to call them devious, but we have a good defense bar in our community, and there are a lot of fine lawyers like Brock that handle these things, and these two may be on opposite sides in these cases, but there is a mutual respect, and there's a sit down and try to resolve things. And quite frankly, oftentimes once you do sit down, disclose what each side's position is, you will find a common ground. And it gets back to what Brock said. His hands are tied a little bit by his client's goal. They're the ultimate decider as to whether or not they want to accept a plea offer. But oftentimes cases are resolved that way.
The vast majority.
Sometimes you will go that next step towards having a motion hearing on issues regarding admissibility of field test or probable cause for the stop. But generally those are the determinative issues, and so even when those motions occur, depending on how they're ruled upon, there may be an appeal, but ultimately the cases rarely go to a full-fledged trial.
Well, one of the reasons, of course, I asked is that our viewing public may not be completely familiar with this, and everybody who doesn't have knowledge of the legal system is, let's say, maybe against plea bargaining, and but the court expects this in some fashion of negotiation. Plea bargaining isn't necessarily a bad word, because if a person's guilty of something, there should be a plea. Am I right about that, you think?
Well, I think that, again, it goes back to the people involved, but the ultimate goal is to do justice. And in a lot of cases, there may be a small hole in the prosecutor's case, or a small hole, or sometimes a very big hole in the defense case. And I think that sitting down and discussing those and what best case, worst case scenarios are, it does facilitate oftentimes reaching of plea agreements. And I think you're right, Mike. That's not necessarily a bad thing.
There are very few cases, Mike, where there is no risk on either side. Usually, and obviously the defendant has some risk because they're on tape, or maybe they've offered a breath test that's over the limit. But the state, meaning the government, is usually not free from that risk either. So for example, if we get a situation where an officer who might not be imposing the field sobriety test in a way that is in compliance with the manual, for example, on the test that we talked about earlier with the woman that called in from DC, there's a test called the walk and turn test. Essentially, it's where you imagine a line in front of you and then walk heel to toe, touching each time.
10 steps down, 10 steps back, as I recall.
9, actually, in each direction.
Well,
and
actually shortened it, haven't they?
And that would be a problem, Mike. If you took 10 steps, that's a clue. That's a clue as to your
Okay.
intoxication. But for example, and we see this sometimes, 4 of the clues, in theory, are to walk on this line. Another one is to not raise your arms more than 6 inches. Another one is to not begin the test until you're told to do so. And so when we get a videotape, a cruiser camera of some of these events, sometimes we get officers who don't tell them to look at a line and don't walk on a line. Sometimes we get officers who don't tell them to not raise their arms more than 6 inches. And sometimes we see officers who don't demonstrate the turn. And then, for example, in a police report, the 3 clues they observed might be those 3 things that the defendant was not instructed to do. And so we're thinking, wait a minute, not only was that test perhaps not conducted in compliance with the law, but they might have passed that test. A jury might decide that they passed it. And so if that's the case, just as a defendant is usually not interested in these mandatory penalties that His Honor described, the government is usually also not interested in taking the risk that someone could walk away scot-free in a situation where there's evidence that they were driving while impaired. And so there is usually some middle realm because neither party is usually free from risk.
Well, let me ask the two of you, Matt and Brock, and you don't get together a lot because there's a lot of cases. There's usually one pre-trial, maybe a second one, or maybe some motion hearings. What is the point, do you all believe, the threshold where there's just no other way of resolving it? Of course, your client and the defendant are in on this too, at which you have to say, this has got to be tried.
Yep.
And you don't try the cases just for fun to try and win like they do on TV. You do it because there's a legitimate issue on both sides.
Sure.
I think that's right, isn't it, Judge?
Okay.
Yep. All right. So what do you think?
Well, and I think kind of to answer your question, then also follow up on what Brock was talking about. I think most of our cases, they're not actually going to be won or lost at trial. They're probably going to be won or lost at that motion hearing, where we're looking at, did the officer have the right to stop the person? Did the officer properly perform the field sobriety test? Was the chemical test properly done? Was the machine calibrated the right way, the way that it was supposed to? That's where most of the issues are, because in most OVI cases, if the person takes a test, the question is going to be, did they drive a car or an automobile, and did they test over? There's a little more to look at when we're talking about the A1A cases that Judge Dressel mentioned at the beginning of the program. But there's not a whole lot of issues for trial. It's usually we're focused on whether or not my evidence is going to come in as a result of the officer's reasoning for the stop, performance on field sobriety tests, that kind of thing.
Mm-hmm. And going a little further, just so our viewers might have a better gauge on that, we live in one of the only countries I've ever been to where police can't do whatever they want. They have to have a justification, so to speak, to remove people from the car in order to impose field sobriety tests on them. The tests they impose have to be good enough, so to speak, with the manual. And if they offer a chemical test, the chemical test has to be done in compliance with what the Department of Health says. And so sometimes those things are done, and we know it, and we can see it on the front end by the paperwork, and sometimes there might be holes there. And the reason why that matters is because sometimes there's a line drawn in time. If those problems are exposed, or if we can see them on the front end, that evidence might not be admissible at trial. And if, for example, if someone gives a positive chemical test, meaning above 0.08, and there's a video of them completely unable to stand, maybe they wet their pants or vomited on themselves and they're driving like a maniac, maybe that breath test might not matter in that situation. But in other situations, if a breath test goes bye-bye, and for example, if we have someone who touched a line or two, wasn't speeding, did not exhibit balance problems, and perhaps there's only a moderate odor of alcohol on their breath, that's a case that might see trial. And they're all over the board in that regard.
Our levels for breath tests are 0.08 for first offenses, and or for the minimum, and 0.17 for enhanced punishment. How does that translate in your experiences to amount of alcohol, so that our viewers might be aware during the holiday season if they are drinking and possibly driving?
Well, I would tell you that to get to 1.7, you have to do there has to be a fair amount of alcohol consumption. And it's interesting how the laws evolved. As we spoke earlier this evening, there was a time when that standard was 0.15 many years ago,
right,
when you were a young lawyer and when I was in law school, and it changed to 0.10 and then to 0.08. And the 0.17 second tier has been with us for probably about 12 years now, maybe.
You can double the penalties,
right,
sort of.
It doubles the mandatory minimums. And that makes the 3 days 6 days, and significantly there are no 6-day intervention programs. There's the 3-day, and then it's 3 in jail minimum. And getting back to what Matt and Brock were talking about, that often factors into a decision. Sometimes too, you have somebody who has taken the test, they have tested over .17. They are looking at enhanced penalties. Sometimes the prosecutor will look at their record or look at the facts of the case, offer them the general A1A that takes it back out from under the mandatory penalties. And that is something that often weighs in. I think that second tier tends to function as a bargaining chip for prosecutors oftentimes.
Yeah. And there are, on that same token, Mike, an individual who's in that situation, there could be complications with that, because most people don't understand what Ohio law says on that subject. I always think of that billboard that's up, the new one, where it has a guy with what looks like a portable test in his mouth, and it says, "You just blew $10,000," and all the defense lawyers are thinking, well, yeah, don't blow that. But really what the sign means is when you drink and drive, that might be the amount of money you spend on attorneys and court costs and fines and things like that. And so the misconception is that where people, and they know that it's not illegal to drink and drive, meaning to have a beer or so and drive. It's illegal to be impaired and drive. And most people think that because I subjectively don't believe that I'm drunk, that I'm not prosecutable or I'm not over the limit. Doesn't matter in most cases. For example, the National Highway Traffic Safety Administration that Matt mentioned a minute ago, they keep very intricate statistics on what somebody can drink versus what their BAC is going to be. And so, for example, and this says on our website, your average 180-pound American male can have about 4 drinks, regular alcohol level drinks, before they get to .08.
Over a certain period of time. Right?
Yes, and then your body gets rid of about 1/5 of that BAC on average each hour. But the problem is that most of the 180-pound males that I know would say, well, wait a minute, I'm not drunk after 4 beers.
Everybody thinks they're okay.
That's right. It doesn't matter, because Ohio law says your breath is above the problematic level.
Well, another one of the issues that I've been seeing a lot as a prosecutor of the 7 years that seems to be becoming more of an issue is the issue of drug driving. We have people that either have, just 1 beer and then they take the regular prescription that they've always taken. They don't realize that it's going to have an effect with the small amount of alcohol that they've drank, or they're just taking a prescription by itself, no alcohol whatsoever, but they're taking it at a level that is impairing them and is making it unsafe for them to drive. And everyone knows you can't drink and drive, but I don't think that we've had the same campaigns for drug driving that we've had for alcohol. And so that's something that people need to be aware of, is that we are not going to be looking just for alcohol. We're going to be looking for what kind of drugs you might have in your system as well. And we're not just talking about illegal drugs. The statute penalizes driving under the influence of a drug of abuse. A drug of abuse can be cocaine, it can be marijuana, it can be a prescription drug, painkiller. So there are a lot of things that, if you're not careful about the amount that you are taking, you may not realize that it's going to impair you, but it is going to, you are looking at liability for an OVI for those drugs.
Okay. We've got 7, 8 minutes left, and I didn't want to leave the program without talking about a couple of things we talked about before the show, which is programs and rehabilitation. We don't want to just talk about the penalties and send the people out into the snow. The courts are actually trying to help them along, and so are the attorneys toward rehabilitation.
Yes, I think as a general rule, in most courts in our area, on first offense OVIs, utilize that option of allowing somebody to go to a driver intervention program. It's a win-win. It cuts down on the cost of incarcerating somebody. Hopefully there's an educational component. We look to the people getting some valuable information, maybe identifying a problem they didn't realize they have, getting a professional assessment, and then if there are recommendations for follow-up counseling, we would much prefer that somebody go through the counseling and deal with the issue rather than imposing more severe sanctions or time in jail. The problem often becomes repeat offenders. I had the experience as an attorney, and I stole this judge's line when he had one of my clients standing there begging for his license, begging for privileges, begging to keep the jail to a minimum. he was a first offender, and the judge said, you know, I hear all this, and I'm going to give you that opportunity. But if I see you again, or if another judge sees you again, you've essentially told me that it wasn't important enough to you to learn from this, and the fact that you may lose a job or have negative consequences if you're back isn't going to be my problem. It is hard to look at somebody and have to sentence them, and that's why we really want to work with first offenders so that they do not become second offenders. One other sanction that we have that I do not use on first offenders very often, but there is technology now called continuous alcohol monitoring. It's a SCRAM is the name of the company that we use, and it is a bracelet that is worn around the ankle that through transdermal readings can measure if somebody's consuming alcohol. That can become a real good deterrent for somebody that's maybe in the process of transitioning into counseling. They don't take that first drink because once they do, they've violated probation, as opposed to the person who's kind of on the honor system and may think, well, I can have one or two. And
who's going to know, right?
Well, probably Brock at 2 in the morning when the one or two become 5 or 6
right.
or 7.
Yeah, that's right.
And when we hear from people about the SCRAM bracelet, we hear very positive things. When there might be these soft factors like their family or their job that stop them from drinking or drinking so much, but when one beer lands you in jail, that's a pretty good incentive not to drink. And when we hear from people who have spent 60 days, 90 days on an alcohol monitor and so they can't drink, they come back and see us and they say, this changed my life, we hear. And sometimes they don't drink after that because they feel great. They've been away from alcohol.
But don't you think that's part of the ethics of representation of this type of person is to not only get them through the legal process, but perhaps start them on to rehabilitation of this particular problem?
Sure. The defense role in the equation is to make sure that they understand everything and then make an informed decision about what they need. But if treatment or potentially an alcohol monitor is one of the things that they think they need, or if we represent a minor, which happens all the time, and their parents are paying the bill, for example, they might want to see their child in that. And then the child, with a talking to from the parent, might say, yeah, that's a good idea.
I think that's why Brock and I Brock and other defense attorneys I practice with are able to resolve as many cases as we do. We really do have the same goals. I don't want to see his client ever again, at least in my professional capacity, prosecuting them. And from the prosecution's point of view, we kind of see things as risks. If a person comes in on a first-time offense, maybe they just made a mistake. I mean, everyone makes mistakes. We're willing to look at it that way, but one of the statistics that I wish was out there more than it is fatal vehicle crashes. 50% of those crashes, there is alcohol involved. So when we see somebody coming in for a second, a third, a fourth offense, now we're starting to see risk, and we're starting to transfer from, well, maybe this person really can't be rehabilitated, and maybe I need to think more about protecting the public instead.
Right.
Have we seen instances, I know this could be a little off the topic, of a combination of alcohol driving and texting or phoning at the same time?
Well, I've heard that I guess people that have done studies on this kind of thing, texting is even more dangerous than OVI, because I think drunk driving, at least somebody's driving the car. With texting, you're just, you're focused on one thing and one thing only. Obviously, we don't want people doing either of those things, but I can only imagine it's a recipe for accident if you're going to do either one.
I can't imagine the combination of those two things. We know the statistics on drunk driving and death and accidents, and then texting, and then once you combine those things, my guess is that you don't add them, you probably multiply them at that point.
Right.
So that would be terrifying if someone was in both of those categories at the same time, to me.
Do we have more drunk driving than we used to when it was practically an epidemic? What do you think, Judge?
I think we have less now. I think that the education, the public service campaigns, I don't have the facts or figures in front of me to necessarily support that. I do see younger people that tend to, as part of their social planning, they have a designated driver They use cabs, they use Uber, they use these services that have arisen to get you home safely. And I know for a lot of people, the thought of having to pay $50 or $60 to an Uber driver because they've been at a party in a big city may seem like a lot, but it is a fraction of what they will spend.
Well, you can always get more money, I guess, but it's pretty hard to get those license and time in jail and all that other reputation. So our floor director tells us we're running out of show here, so we would like to thank 1 minute. Yeah, I'll talk slow. Yeah, it's been great having you all. Judge Fred Dressel from Kettering Municipal Court, Matt Courtjohn, assistant prosecutor. Who's the real prosecutor? Everybody's an assistant. Matt Courtjohn, City of Dayton. You don't have to answer that.
Stephanie Cook, City of Dayton prosecutor.
Stephanie.
We're giving her a shout out.
Yeah, okay. Stephanie was on the show a long time ago. She was an assistant prosecutor. Enjoyed having her. And, of course, Brock Shaneline, working with our old friend Larry. Larry used to give us some field sobriety tests here in the studio. So, Brock, great to have you also.
If we do it again, we can do that sometime.
All right, great.
Hopefully everyone passes.
We'd like to thank all the volunteers behind the scene who've made the program possible. I want to thank everyone involved. You've been watching You and the Law. I've been your producer and host. I'm Mike Monta. Good night, Lily and Katie. We'll see all you viewers again next time. And drive carefully. Don't drink to excess. And Happy New Year. Good night.